Hi everyone. I'm going to continue with registration of charges chapter. I'm Rajarajeshwari, a chartered accountant, cost accountant, and a company secretary. And in the previous class, we saw about what about registration of charges, what is modification of charge. In today's session, we will be seeing what about satisfaction of charge, what is meant by satisfaction of charge, what are the procedures that you should have to follow, is there any register that needs to be maintained by the company, and I will also show you samples of how the registrar gives you the certificate. So in today's session, we will start with satisfaction of charge. So, what is satisfaction of charge? A company has borrowed, say, 5 crores worth of rupees from the bank. 5 crores worth of loan from the bank. Now, its position got improved or it wants to repay and settle the debt. So in that case, can it repay once the money is repaid? Suppose SBI ABC Limited has obtained a loan of 5 crores. Now this company wants to repay this 5 crores. Now once it is repaid in full, when I say in full with the interest no due, then the loan has been settled. Then at the time of giving the loan, it would have created a charge. That charge needs to be closed because it is live stating that the loan is still pending. Now, what is the procedure when you take a loan? You take a loan, you register the charge with the registrar of companies, right? You have taken a loan. So first, when there is a creation of charge, when you take a loan. Now this you have intimated with the ROC. Now when you have settled the dues, that also needs to be intimated to the ROC because he would have created a charge ID for this charge, for this SBI loan. So that needs to be settled, right? That needs to be given, informed to the ROC what is that the loan has been settled. So for that, you should have to take. Okay, I will increase the font size. Now is it visible? So you have to intimate it to the ROC that you have settled the dues. So only then he can close the charge. Otherwise, in the MCA 21 portal, in the MCA portal, this charge will show it as that APC Limited is having a charge with SBI to the extent of 5 crores. It will be open with the charge ID, SRN number, everything will be visible there. So once it has been closed, this charge will not be visible. So only the existing loan will be visible. So this is called as satisfaction of charge by the company. For that, what you should have to do, the company should have to file. We all know that CHG is the form for charge. So the company should have to, after paying to the bank 5 crores, it should have to intimate to the ROC in form CHG4 that it has repaid in full within 30 days of satisfaction. So if it has repaid on 1/1/2026, it should have to do on or before 30/1/2026. It should have to intimate it with the ROC that the charge has been satisfied. So if the company has failed to intimate it, then is there any option? Yes. It should have to intimate it within 300 days. The ROC, if it is not intimated, by paying additional fees, the company may try to close the charge. The ROC may allow up to 300 days. But of course, ROC will collect additional fees for the delay. Now the ROC is there. Now the company has intimated to ROC. Now ROC just like that cannot close the charge. It will ask the bank whether the charge has been, the loan has been settled, the charge is closed, or the any amount pending. See, just like that the company should not go and try to close the charge. So the ROC will give some time limit as to why should not be recorded, as to show cause as to why that satisfaction should not be recorded in the register maintained by him. So for that, the time limit is 14 days. So within that 14 days, the banker should have to say, if he has got any objection, he should have to give his objection. If any cause is shown, any reasonable cause is shown, then the ROC will intimate the company that there is an objection, so the charge cannot be satisfied. It cannot be entered as closed. So that cannot be done. Or if there is no objection by the bank, then the ROC will proceed with satisfying the charge. Then it will issue a certificate of satisfaction of charge with his seal. So this is the general procedure, right? We will see one by one. The company shall give intimation to the registrar in form number CHG4 within 30 days of the payment or satisfaction. Then if not intimated, so this is the procedure. If the company has failed to intimate it within 30 days, then there is an option. Then the registrar may allow intimation within 300 days. If not intimated, if company has failed to intimate within 30 days, then the registrar may allow giving of intimation within 300 days. But for the delay, you have to pay the additional fee, prescribed additional fees within 300 days. Because the charge has been settled, the loan has been settled, so he is given this option. So I'm not able to zoom in PPT. Just a minute. but it is more just an. Yes, yes. I'll increase the size. So if the company has failed to intimate it within 30 days, then the ROC can. So he can allow intimation within 30 days. The ROC can allow, if the company has failed to intimate within 30 days, the ROC can allow 300 days. But of course, additional fees should have to be paid by the company. That is there. Then the registrar will send a notice to the holder that why within 14 days the payment or satisfaction should not be recorded. He will get the no objection from that, so that he will wait for 14 days whether there is any objection from the bank or the charge holder as to why it should not be recorded. And when no objection has been received, he will give the satisfaction of charge. If any objection has been received, so you want me to explain the first point. See, first one, the company is intimating in CHG4 within 30 days. Once it has cleared the debt, it should have to file form number CHG4, which is for satisfaction of charge, that it has repaid the amount in full. Suppose the company has forgotten on 1/1/2026, it has satisfied the charge. So within 31/2026, it should have to intimate. It has forgotten, it has failed to intimate it within 30 days. Then it has got an option, it should have to intimate within 300 days, but it has to pay the additional fees. Then the registrar will see to it that it is genuine. So he will ask the charge holder whether it should not be recorded. Yes, what is it, Sharmila? Intimation, giving notice. Intimation meaning is giving notice. You are saying that it should have to tell or give it in consent or give it in writing. So that is called as intimation. The company in form CHG4, it gives in writing that it has completed or it has fulfilled or it has satisfied the charge. It has repaid the loan in full. That is the intimation. Make known to the other party. That is intimation. So within 14 days, the ROC will wait to, if there is any objection is going to be received, he will wait for the objection or the query to be raised from the bank. If the bank is silent or that doesn't raise any objection, or the bank can raise the objection if no satisfaction of charge. On in the sense the bank has got certain objection, certain amount has not been paid, it could be anything. Then if any sufficient cause is shown, then it will record a note in the register of charges and the ROC shall inform the company. Only after completion of all the things, the company can register the charge, satisfaction of charge. So if show cause notice is received, then no cause is shown, then the registrar shall register the satisfaction or payment, issue a certificate of registration, and that will be the conclusion. He will give it in form CHG5. So form CHG4 is your application. In form CHG5, he will give you the certificate of satisfaction of charge. No notice in case the intimation is in form CHG and signed by the holder of the charge. Then he need not proceed with it. He need not wait for that no objection. Then the person also has signed it and given, so no objection, so no notice be given. That is an exception where no notice will be given by the ROC. Then in that case, he can straightaway proceed as soon as he receives the CHG4 from the company. Their attachment will be there. So the banker also would have consented. Then there is no problem. He will proceed with satisfaction of charge. And this should be preserved for 8 years. Generally, it is preserved for 8 years. Any documents, it should have to be preserved. But what in practice we do it is that suppose you have settled, but the company should have to preserve it for better to preserve it for unlimited period because it is a proof that it has satisfied. Later on, after some time, a query arises, then it should have a document. At least the soft copy should be there to prove that it has satisfied in full and the certificate is there. If any issue crops up, then it should be in a position to prove it. So what we say is that it should be preserved. Shall we proceed with the next? Any doubts in this satisfaction of charge? This is the
Ma'am,
procedure generally.
ma'am,
Holder of charge is charge holder is the bank. It has got a lien, right? So that is he is the charge holder. The lender is the charge holder, the bank. Third point. Okay. This 14 days. See the ROC now the company has specified that it has satisfied the loan amount. It is asking the ROC to close the register stating that the charge has been satisfied. Charge has been satisfied means no loan. That is the meaning. Satisfaction of charge means no loan is existing. No loan is pending. So before closing the charge, what will happen if if the loan has not been settled by the company? And the company has made an intimation, the ROC is taking the precaution when it is not signed by the banker or banker has not given his consent or there is no proof available in that form because normally in a form you have to attach that the loan has been what we used to do is that the banker will give a letter. This is to inform that the company ABC has uh, given back as repaid the amount in full and to whomsoever it may concern or it will be signed by the bank manager. That will be given on which date that also he will give. It has been satisfied in full. So he will give a letter in the letterhead of the bank or the bank manager will give or whoever is authorized the respective official will give. That will be attached in charge 4, CHG4, and it will be intimated to the registrar. Now, if no such sign is there or the ROC has got a doubt, then he can ask the bank as to what is before shown, what is written. Show us within 14 days as to why payment. See, this is the general procedure with government ROC or any government. They will say why it should not be done, why I should not give a certificate of satisfaction of charge. So that is the general procedure from the government, that why it should not be done. So then the banker should have to intimate. If he has got any concern, if he has got anything to say, he can intimate it to the registrar. Otherwise, he need not give any objection. So he will specify any objection if he wants to raise, that should be done within 14 days. So that is the general procedure. Because the ROC is getting an intimation from the company, now it should have to give it to the other party. See, I will give you an example. Now you are saying, I have repaid. I will give you an example. Now X has paid Y. He has borrowed, or this is the bank. Now he has paid 5 crores. Now your ROC is not in the picture. Now he is the lender, the bank is the lender, then he is the borrower. In our case, ABC. ABC is the borrower. The transactions are taking place between the lender and the borrower. He is only the person who is just intimating, or he is showing it for the sake of the public. He is just maintaining his register and he is entering that details in the register. How will he know when the borrower approaches the ROC and he says that he has settled the 5 crore rupee to the bank? Now, this ABC Limited is saying to the ROC, I have settled 5 crores. Now, it is the duty of the ROC to check it up with the banker whether this person has settled. Can I register the satisfaction of charge? So for that, this ROC will give a show cause notice as to why it should not be registered. So he is asking from this bank as to why it should not be registered. It is like saying, I am going to register. If you have any objection, you tell me within 14 days. Otherwise, I will proceed with the registration. So that is the intimation. For that, the bank is having 14 days time limit to raise the objection if any. So that is the meaning of within 14 days, the charge holder, that is the banker, can raise an objection with the registrar. No, don't register the charge, satisfaction of charge. That he can raise it. Suppose the time limit has gone, then ROC will register satisfaction of charge. Then after 14 days, banker should not say, no, I was not aware, I don't know, it should not have been registered, nothing. He has given the time limit is 14 days. So why it should not be recorded? So that he gets the consent from the banker that he is going to register the charge. If he has any objection, he should have to intimate the ROC. If no cause is shown, then the ROC will register. Suppose he has got any objection. No, the bank is in a dilemma. No, why? What is the dilemma? Whether it should have to say whether it has repaid 5 crores? Yes, no. Why the confusion with the bank? It is they are dealing with money, right? Whether the question is, the banker will say whether 5 crores paid. Yes, no. If the banker says no, he will raise an objection. If the banker has received the money, no objection. Right? So the banker will not be in a dilemma. It will intimate. That's why 14 days time limit is there. The banker will look into the records and it will intimate. That's why it will give in writing. So to raise all those confusion, to avoid all those confusion, what they do is that it has been settled in full. It will attach. Yes, ma. What is your doubt? Yes. Two persons have raised the hand. Yes. Okay. So then, if any cause is shown, suppose the banker objects, then what they will do, they will see to it that if there is an objection, if cause is shown, then ROC will not issue a certificate of satisfaction because there is a issue. So after that has been solved, for that what he will do, he will record a note because the charge 4 has been, CHG 4 has been submitted to him. He will make a note there that objection has been raised. So only he has received the objection. So he should have to intimate the company. So that he will intimate the company, he will inform the company that the charge cannot be registered. Satisfaction of charge cannot be registered. So he will intimate the company. Then after the company does all the procedure or any legal formalities, it could be due to legal formalities has not been complied with, or the loan amount has not been satisfied, or the interest amount, it could be anything. It is between the bank.
Ma'am, from whom ROC will receive intimation, ma'am? In the third point?
Third point.
Yes, ma'am. From whom ROC will receive intimation?
That is the CHE4 is the receipt. See, on receipt of intimation is nothing but that CHE4, the ROC has got, no, that is the intimation.
Okay, ma'am. Okay.
See, the company is filing on receipt of intimation means the company has filed CHG4, no? So that is the
Okay.
intimation. So that is
Okay,
on
okay.
filing of
Which means they
CHG4
have
by the
filed.
company. That is the intimation that it has been satisfied in full. See, whatever you want to intimate to the ROC, it will be only by forms.
Okay, ma'am.
So in forms only you should have to do it. So CHG4 is the intimation by the company that it is filing that form. So that is the intimation to the ROC. So then it will allow. So this is filing of CHG4 by the company. Right? Shall we proceed further?
Hello, ma'am. I am Harshal.
Yes.
Ma'am, if we can say as in the satisfaction of charge as a in case CHG4 form are duly signed by the charge holder and the borrower, right, ma'am?
Yes.
Then it is not obligated. Then we not
Yes,
required to
it's
follow this procedure from
yes,
the three
yes,
entities.
yes. It need
If
not
it is
ROC then.
if it is not duly signed, then we require to follow this procedure for the satisfaction of charge, right, ma'am?
Yes. If the banker has also given his
And
certificate in the signature that has been attached in CHG4, then ROC can straight away proceed with issuing the satisfaction of charge. Only if
ma'am,
any.
preservation of records 8 years is given in the model. So
Yes.
in that means what mean by that, ma'am? I'm not understood to this means
See, if
they
any
are required
charge.
to.
Yes, yes, I'll tell you. If you have settled the charge, meaning you have settled the charge on, say, you have paid the money on 1/1/2026. Now, this document should have to be preserved for 8 years from the event. What is that 8 years from that event? So 2026 is the event, 1st January 2026. you have settled the dues. So 8 years from that, if you take, it comes to 2034, right? So this is called as preservation of records for 8 years. So the event has taken place on 1/1/2026. That documents should be preserved connected with that event should be preserved for 8 years from the date. So you should have to preserve the documents very carefully till 2034 at least. At least till 2034, you should have to preserve these documents. That is the meaning for 8 years. So after that, if anything comes, then you can say the time limit has expired, then no issue. At least the minimum period of preservation, not only for this, for any creation of charge. Creation of charge, you have to maintain it till you settle, and after that only you get a preservation of charges 8 years. Now, this will not be applicable for creation of charge. You have not settled the charge. So I am using this word preservation only it is in satisfaction of charge. You would have created, suppose it is creation of charge. 1/1/2026, you have created a charge. You have not satisfied it till, it could be even till 2036. You would not have satisfied the charge. The charge will be alive. So in that case, you cannot say that you will preserve the charge only for 8 years. No, you should have to preserve till the charge is settled and after that 8 years.
Then
So
means 8 years is not actually for the all. In case अगर 10 साल का होगा charge period, so in that case we can say कि 10 years as a presumption years, right, ma'am, for the charge.
for the satisfaction of charge, the issue is closed. The settlement loan has been done. Then after the settlement has been done, you have to preserve it for 8 years.
Okay, it means required to the time of the loan, right, ma'am, for the
Yes,
duration of
it
the
is
loan.
always better to maintain the thing till the loan. See, I will tell you practical difficulty. Now you have got a loan for 5 crores. Now so many, I will tell you the practical difficulty. One banker or one Mr. A in SBI would have given the loan, then he gets transferred to some other bank or some other officer will come. So he may not be aware of that. Anyway, it will be recorded in the thing. They will keep track of that thing. That is not an issue. But still, you have to show it. You have to preserve these documents, and if any dispute arises, you should have to show it from your side, the company side, that they have borrowed only up to 5 crores, or what is the loan, what is the conditions. See, it could be anything, no? Some floods come, so, or the system crashes. It could be anything, any natural calamity would have come. So, generally we advise them to preserve. If it is a creation of charge, that we advise our clients to maintain it till the satisfaction, and from the date of satisfaction, we just ask them to preserve it for 8 years so that if there is any issue later on coming, then they will be in a position to show that as a proof or they can settle the dispute. That is
Ma'am,
the
we can
reason.
say it could be a extend no? Beyond the 8 years if the loan
Yes,
amount is not
yes, yes, yes. Preservation, when the law specifies 8 years, that is a minimum period of 8 years.
means as
Maximum,
per
if
law.
you can hold, there is nobody is going to restrict you. Why you are holding for 15 years documents? Why you are holding it? Nobody is going to question you. The rule says at least preserve it for 8 years, because at that time they can ask you if any question issue crops up, you should have to preserve it for 8 years. Then you can do it. There is no hard and fast rule. You can even preserve for 20 plus years. Nobody is going to question you. Why are you keeping the old records? It is left to the company.
Means it
The
could be
law says
2024 or 36, 37 even. In your case,
yes,
you
yes,
said. Okay, ma'am. Understood, ma'am. Thank you.
yes. We shall move on to the next.
Hello, ma'am.
Yes.
I have a doubt in point number 2.
Okay.
300.
300 days. That is the general thing given. 300 days.
In 300 days, 30 days is included or excluded?
Yes. 300 days, 30 days is included. See, within 300 days on payment of prescribed additional fees. Yes, within that 300 days, that 30 days is included because it has been given within 300 days. He has not given for a further period of 300 days. The act would have been specified. Your question is 30 plus 300 or only 300. It is only 300. That
Yes, ma'am.
300 includes this 30 days.
And within 14 days, it start from where to where?
Within 40 days from the intimation, the registrar is having that he is getting that CHG4 filed by the company, no? So the registrar
Yes,
will
ma'am.
give an intimation to the bank after getting it. So he may take some 2 days to process. The moment he asks the question, the time limit for the banker to intimate it to the registrar is 14 days. Now the charge has been filed, form has been filed with the ROC. Say you are today 28th March, you are filing the CHG4. Now ROC is taking, or 27th March, the company has filed CHG4. Now the ROC may take, I will write it here. See, on 27th March, the company has filed CHG4. Now, ROC, he takes it on 1st April, assume. So, 1st April, he gives an intimation. He asks the intimation to bank. So, on 1st April only, he has asked the banker. Now, the banker can give his reply within 14 days, within 14/4. As to if he has got any objection, he can raise the objection. The question is within 14 days, when the ROC intimates it to the bank, the banker will be given 14 days time limit to raise the objection. That is the meaning.
Okay, ma'am. Understood.
Okay. We shall proceed further.
Thank you.
Right. Just a minute. I will stop sharing. Okay. The power of the registrar to note satisfaction and release the charge. So what the registrar can do, he can make entries in his register. So he is maintaining a register. So in his register, in ROC's register, he will make a note that this charge has been satisfied. So he will note. So he will wait for 14 days, or if there is no intimation has been received by the company, the registrar is empowered to make the note in that register, in the register of charges. Or in case there is evidence, if evidence is shown to the satisfied that the satisfaction has been done or satisfaction as charge has been done, whether the debt has been repaid in full or you would have given a property as a security. That security has been released from the charge. So either the debt has been repaid in full or property has been released and the property has been sold or it ceases to be, the property ceased to be a part of the company, ceased to be a part of company's undertaking. So in all these cases, the registrar can make entry and it will release or it will give the entry that the charge has been satisfied in full. So the registrar can enter in the register of charges a memorandum of satisfaction to that effect. So what they can test you, what are all the cases wherein the registrar has got power to satisfy. So he can make entries even if no intimation has been received by him from the company. So even in that case, he can satisfy provided that the debt has been satisfied in full or the property has been released. When will you release the property? Only it has been satisfied in full, it will be released. So the property or the undertaking. You remember on the charge thing, we learnt that it could be on the property or the undertaking of any of the property or both. The first charge definition. So the undertaking or the property has been released from the charge or that property is no more with the company. So even in that case, it amounts to satisfaction. Only satisfaction after the satisfaction has taken place, the banker would have released. So in all these cases, he can enter that in the register maintained by him. He maintains a register. It is an ROC's register. He will intimate it. So once he writes it, once he issues a certificate, then in the portal it will be there that satisfaction has been done. So the charge ID will not be there alive. So that amounts to satisfaction of charge. Then what is the power of registrar to note satisfaction? So for that, he will inform the affected parties within 30 days of making the entry in the register of charges. And then he will issue a certificate in CHG 5. See, in CHG 5, he will issue a certificate. That is a certificate of satisfaction of charge. So he will issue a certificate. He enters in case the registrar enters a memorandum of satisfaction of charge in full, he shall issue a certificate of registration of satisfaction of charge in form number CHG 5. CHG 4 is the application by the company to the registrar and the registrar will issue the certificate in CHG 5. Then. Okay. See, depending on the delay in registration, the additional fees will be calculated. See, this additional fees is a procedural thing. So, it will be calculated in the portal. That additional fees, depending on the delay, it will be calculated. I'll tell you. In which case the banker will come in the picture. That is, if the satisfaction is done, the banker has issued a certificate, then there won't be any objection.
Ma'am, could we say कि it's this additional fee in a section 82 is will be ad valorem fees?
Not ad valorem fees, because they have not mentioned it as ad valorem fees. It is only mentioned as additional fees. So in the portal, you will have a thing, how many days delay, depending on that, the fees will be automatically calculated by the portal. Suppose if there is a delay within 300 days, the fees will not be the same. So it will be an additional fees. Depending on the delay in filing, your additional fees will get increased. It's not ad valorem fees, because the law says that it is only additional fees. Ad valorem means on the value. Ad valorem. So that comes only in creation of charge or modification. It will not come in satisfaction of charge. In satisfaction of charge, only 300 days.
Okay, ma'am, clear.
Okay. So there is an, if the receiver has been appointed, or if a person obtains an order, say a receiver has been appointed to manage the property, then you have to intimate it to the ROC. You should have to give an intimation to the ROC that a receiver has been appointed to manage the property, or the company has appointed a receiver, then that should be intimated. Or if a person appoints such a receiver under any power contained in any instrument, it has got a power, and using that power it has appointed a receiver. In either case, either it obtains an order or it has got the power. So here, through an order, the company appoints a receiver, or it has got the power. Either case, it should have to give an intimation to ROC that it has appointed a receiver, and it should be intimated within 30 days. 30 days is the general time limit for intimation to the ROC in majority of the cases. So from 30 days from what? From passing of the order or your appointing. So within 30 days, the company have to intimate it to the ROC that a receiver has been appointed. So that should have to be intimated to the ROC. So within 30 days. Then. Now the registrar, after getting the prescribed fees.
Ma'am, sorry to interrupt, but here intimation for receiver. So receiver from whose side, ma'am? Is it like from company side someone is up, they'll appoint, or from the ROC side they are going to appoint the receiver?
No, from the company side only. See,
Okay.
company is doing an action. So that action should be intimated to the ROC. So for that, it is intimating to the ROC that a receiver has been appointed. So within 30 days of the appointment, you should have to intimate it to the ROC. That is the concept.
More like a point of contact, is it?
I don't get you.
More like a point of contact for the ROC to reach out
Yes,
to the
yes.
company.
Whatever
Okay.
the company does, that should have to be intimated to the ROC. That is the concept. So it is doing.
Okay.
So the ROC will write that, make a note in the register maintained. In the register of charges also, it will note that particulars. Now he is having a register, right? ROC's register is there. In that also, he will make a note that particulars of receiver, whatever is the instrument, all the details will be mentioned in the register of charges, which has been maintained. Now, he ceases to hold such appointment. That also should be intimated by the ROC. Now he is appointed. Now he is ceasing to hold an appointment. Now he is no more a receiver. So even that has to be intimated to the ROC. And shall register, the ROC can register such notice. That also should have to be intimated to the ROC. That is the concept. See, whatever the company does, it should have to be intimated. That is as simple as that. And the ROC can notice it there. Now, if a person fails to comply with the provisions, what is the punishment or what is the contravention provisions? If it is a company, it shall be liable to a penalty of flat penalty of 5 lakh rupees. If it is a company, it is a flat 5 lakh rupees. If it is every officer of the company, you should have to write every officer of the company who is in default. Every officer of the company who is in default. Both are important. If you write it as officer in default, no, answer is not complete. Every officer who is in default shall be liable to a penalty of 50,000 rupees. If the company is in default in complying with any of the provisions of this chapter, if you simply write, if the company is in default in complying with the provisions of this chapter, the answer is not complete. With any of the provisions of this chapter. So even if the single provision is violated, any of the provisions, then the company shall be liable to a penalty of 5 lakh rupees. And every officer, it is not only the company, every officer who is in default is also liable to a penalty of 50,000 rupees. Now there are two officers in that company, Mr. A and Mr. B, Mr. C. Now these two are the person who are involved in that default. So every officer in default. So A is liable for 50,000 rupees and B is liable for 50,000 rupees. That is the meaning of every officer in default. Every officer of the company who is in default shall be liable to a penalty of 50,000 rupees. The company as a whole, it is liable to a penalty of 5 lakh rupees. What for it is liable? Because of its failure to comply with any of the provisions of this chapter. So for that it is liable. Right? Then. Okay. Punishment for fraud. Fraud in the sense, purposely, if a person has, when do you use the word fraud? You would have read in Contract Act. Fraud is a very costly word. The intention to deceive should be there. It should be done intentionally, willfully, purposefully. with an intention to deceive the other party, then it amounts to fraud. So if a person willfully furnishes, willfully, wantedly, knowingly, so knowingly, purposely, wantedly, so willfully is the key word for this. If any person willfully furnishes any false or incorrect information, false or incorrect information, or suppresses any material file. Suppresses means it is his duty to say, but he is not saying that material information. So suppresses any material information, meaning it is his duty to disclose, but he has not disclosed, but not disclosed. That is the meaning of suppression, or suppresses any material information purposefully he has not given. So how you should have to read: if any person willfully furnishes any false or incorrect information, if any person willfully or knowingly suppresses any material information which is required to be registered under this section 77, he shall be liable for action under section 447. 447, it is a case of imprisonment and fine. It is held for fraud. For fraud, he will be taking action against that fraudulent person under section 447. So this 447 is a general section which talks about what is the punishment for fraud. So he is liable to imprisonment and penalty and fine. So both he is liable. So that is the punishment for fraud. So you have to write all the points. This willfully is the key word. Willfully furnishes, purposefully. He gives a false or incorrect information, suppresses any material information which is required to be registered under section 77. Then he shall be liable for action under section 447. 447 talks about penalty provisions with regards to imprisonment and fine.
Ma'am, I have a doubt in section 83.
83, okay.
Yes, ma'am. So where the registrar is making entry for satisfaction of the charge, so there it is said that even if there is no intimation given has been received by him, still he has
Yes.
to make the entries. So how is that possible, ma'am? If he doesn't,
Yes, if he knows that if he comes across, he is empowered. He has got that power. The Act says the ROC is given that power. So the powers of the registrar, if they ask you what are all the powers of a registrar, even if the company doesn't intimate it, ROC has got the power to register the satisfaction of charge. If he comes to know that the amount has been repaid in full, or see, it is a discretionary power. What is the meaning of power and right? See, it only says the power of the registrar. He need not exercise this power. See, the
okay,
Act says the ROC has the power. He can do it, but he will not do it in practical case. The Act says he is empowered.
okay, okay,
See, he has got that right, no? He has got that power. He can use it, he need not use it. Practically, no ROC uses that power, but the power is there. As a student, you should know what are the ROC's power. So it has been, they will test you what is the ROC power. Or if they ask you, has ROC what are the powers of ROC? Then you should have to mention that. Even he has got a power even without receiving the intimation from the company. If he has the knowledge that the debt has been satisfied in full or the undertaking has been released, or it is ceased to be in the power of in the possession of the company, then he can do so. Yes,
Okay.
without support document, if he is aware, he can do it. But he will be questioned in practice. No ROC does that, exercise that powers. See, when I say powers, it is left, he is empowered. It is left to ROC to exercise that power or not. He will not exercise it in the practical case.
Okay, ma'am. Ma'am,
So
and also
just
section 84, I did not understand.
section 84.
Yes, ma'am.
Okay. Intimation. So if the company appoints a receiver to manage the property, then it should have to intimate it to the thing. I will give you with the help of an example. So then it should have to intimate. See, the company has appointed a receiver. So in that case, whether it has appointed a receiver, how will the ROC know that the receiver has been appointed for the charge? So it is the duty of the company to intimate it to the ROC within 30 days that a receiver has been appointed. So that will be taken care of, that a
Okay,
receiver has
and
been
here
appointed.
it is also mentioned that notice of such appointment shall be given to the company and the registrar. So if company is appointing, then why is notice being given to the company?
No, no. Company is not appointing. Now, for that, under any power contained in the instrument, suppose the banker is appointing, not the company is not appointing.
Okay.
The company is not appointing. So, the banker on on any basis the receiver has been appointed, then they will intimate that thing to the company also.
Okay, so here the banker is appointing the receiver.
Banker could appoint, or any third person could appoint a receiver. Banker
Okay.
generally.
Okay.
So in that case, the third party appoints, no? So it will be intimated to the ROs.
Yes, ma'am. Understood.
Okay.
Ma'am,
Yes.
in such a section 84, in that
Hmm.
intimation of appointment by the charge holder, right, ma'am? It could be
Yes.
appointed by the charge holder on a such
Yes.
a charge.
Yes. It could be
Okay.
appointed when the receiver, that says when a receiver has been appointed, it is the duty to intimate the ROC that a receiver has been appointed.
It could be appointed by the charge holder.
Yes, yes.
Okay, ma'am.
Okay. Now, if there is any rectification that needs to be done, now the central government can do the rectification. What was that? When there was omission, what are the circumstances? When there was omission in giving the intimation to the registrar with respect to payment or satisfaction of charge within the specified time, then it can be rectified by the central government. Or when there was omission or misstatement of any particulars in any filing previously made with the registrar. So any particulars, wrong particulars given, that needs to be rectified. Suppose it could be a property was wrongly written, or survey number was wrongly, it could be anything wrongly mentioned, or any particulars in filing the charge. So that particulars need to be corrected. Rectification means correction. And that could be rectified by the central government. But the central government should need to be satisfied it was not willful or deliberate. It was not willful or deliberate. Purposely, they have not done that. It was an accidental omission. All these words are very, very important. When we file a letter or when we write a letter to the central government, we will add these words. It was neither willful nor deliberate. It was a mere accidental omission due to inadvertence. All these words are important. It by inadvertently that mistake was done. It was accidental. Then,
Ma'am,
yes,
can you explain once again? I don't get it actually.
okay. See, if any mistake done, that can be rectified by the central government. The central government can order rectification of register of charges. Whenever there is a wording central government, you use the word order. Who can order? Central government can order rectification of register of charges. When in cases of default, what are all the cases? When there was an omission, you have not intimated to the ROC within the specified time. See, 300 days also it has gone. So you come to notice that after 310 days or 320 days, you have to move an application to the central government.
Okay.
Then at that time it can give an intimation, it can order rectification of because the act is saying within 300 days. Now the company has failed to satisfy the charge, failed to give intimation to the registrar, beyond 300 days has gone. Now there is a omission by the company. So in that case, the central government, you have to make an application to the central government. What practical procedure we follow is that we follow the petition, or we follow the, earlier it was 141 petition, now it is, you can make an application to the central government that the delay was inadvertent, it was not deliberate, it was not willful. By a mistake, we have failed to intimate the satisfaction charge with the registrar. Kindly condone the delay and register the satisfaction of charge in favor of the company. So it should have to attach all the documents. Then the registrar, the RO, that is the central government, can order rectification, can intimate, can order ROC or any other officer in that department to rectify that. Generally, he orders the ROC to rectify that, and the satisfaction will be entered in the register. There was omission in giving intimation to the ROC, or there was an omission, misstatement of any particulars in any filing previously made to the registrar. In these two cases, but the central government has to be satisfied that such default was accidental, it was not willful. Accidental means by mistake. Accidental means by mistake. It was negligence due to inadvertence or because of
Ma'am,
some
what
other.
is inadvertence?
Inadvertence means carelessly, they have not meticulously calculated. They have slipped seeing that, or they have omitted going through that. It was not done purposely. It was
Okay.
done by mistake.
Hmm.
See, you should have to meticulously do it. See, your mobile phone recharge, you have to do it. Say today is the last day. You have missed it. Then
Okay.
tomorrow only you are reaching. Are you doing it purposely? No, no. By mistake, in a work pressure, you would have omitted to recharge your mobile. Same thing. The
Okay.
company has done it inadvertently. It has
Means
slipped. It has.
carelessness.
So that is, we won't do it purposely, no.
Means
So
you want to say
when
something like it is being done only by carelessness. Means it is done by fault, not
yes,
deliberately.
yes, by mistake, it has
Okay.
not counted the days, or it has failed, or it could be due to any reason, some change in the company, or it could be any reason. They should have to give the reason why they missed it, or probably the accountant who was, they will say the accountant who was in charge of that has moved to some other thing, or they will say all the practical difficulties. No, on that time they would not have meticulously calculated that 30 days they should have to take it. Generally 30 days you should have to do it, or many person would have omitted that they have created the charge. If it is one charge or two charge, you will be able to do it. Practically, if the company has got so many charges, you will slip. No, there is a possibility of a mistake. Human error is there. It is a human error. It was not purpose. So that is inadvertence. They have missed. They have missed the thing. That is inadvertence, or because of some other sufficient cause. And it should also not prejudice the position of creditors or shareholders, because of it should not, they should not be affected, meaning the creditors or shareholders should not be affected by this. They will ensure, the central government will ensure. So in that application itself, we will say that it will not prejudice the position of the creditors or any of the shareholders. Kindly condone the delay and uh, s- uh, make entry in the register of charge. So that will be done, and then the thing will be closed. The settlement of, or the satisfaction of charge will be done.
Excuse me, ma'am.
Yes.
Ma'am, while appointing the receiver, like suppose let us say bank has appointed the receiver. Ma'am, could you please tell me what is his role? What all duties he will be performing? Will be under the control of a bank, or how can the ROC
Okay,
finalize
I will explain to you. I will explain
all
to
his
you in
activities?
detail. Okay, I will explain. I will take that separately after I complete the other topics.
Okay,
So
ma'am.
I will
Thank you.
take it. I will take it up. I have made a
Okay,
note
ma'am.
of your
Thank you.
thing. So I will do it.
Okay, ma'am. Thank you.
I will explain that. And which the person has given two questions. That also I will solve. Don't worry. I will take it up. Once I complete this topic, I will take your doubt solving session. We will have it. Don't worry. I will clarify your doubts then. So the application should be made in CHG 8. Now you are making an application to the government, right? So that should be made in CHG 8 by the company, or it could be any interested person, that then the order of rectification will be made by the central government. See, whenever central government you get, you have to write this word order. Only then it is correct. This word is very important. Order of rectification shall be made by the central government. So what it will do, then another thing is that it will direct rectification. See, the word used is that order, direct rectification. You have to use this word. See, the central government has only got the power to make an order. It directs, do this, do that. So it directs. So you have to use the word order, direct. This word should be there in your answer. Only then the answer is complete. This should be used only when you use the word central government. So the central government makes an order. The central government directs in any act you see, or in company law, in anything you see, direct order, then immediately central government. These words you should have to remember while reading. Direct rectification of the omission or misstatement of any particulars in any filing. This is a solution for the problem. See, previously we discussed the problem, right? Now this is the solution for the problem. What is that? A direct rectification of what? Of that omission or misstatement of particulars. Or it can direct extension of such time for satisfaction of charge. If it was not made within a period of 300 days. So beyond 300 days, or say in the case of 350 days, the company comes to know, then it should have to file CHE 8 to the central government. Then the central government will find out whether there is a sufficient cause. Then it will make an order. It will direct the ROC, the respective ROC, to register, to give time for rectification or correct the omission or misstatement of any particulars. For that, the company should have to file on an application filed in form CHE8 by the company or any interested person, even the banker. So in that case, the central government can direct. May, the word is may, means it has got a power. It is a discretionary power. It may an application, it may direct rectification or extension. So two things. The central government may direct rectification or it may direct extension of time. That is with additional fees, even after 350 days, they have to pay that additional fees and they can get the satisfaction of charge. That can be done. That is the meaning of extension of time. Or sometimes on the 300th day, they will do it. The night the portal may not work. They may not be able to file. So it will go to 301 days. So they will wait till the last day. So generally we advise we do it well in advance. So they should have to go. They should have to file CHG8 and they should have to get the order from the central government. That is the procedure. So they can ask you the question, is there Mr. Yes comes to your advice, he has forgotten to file the satisfaction of charge within 30 days and even after 300 days has expired, is there any solution available? Kindly advise as a professional. I can ask the question that way. Then he is indirectly the question test you on this particular concept. You have to write all these points there. So rectification by the central government under 87 could be done. Then we will see what is the register of charges. In 1 minute. No. See, if the company has delayed beyond 300 days, it has not filed a rectification, then it can ask the central government, it can make an application, it can file CHG 8, then the central government will interfere and will order or direct rectification or extension of the time. See, is my screen visible to you? Right?
Yes, ma'am.
Yeah, okay. Now,
Yes.
there is a register of charges that has to be maintained by the company. Now, the company is has a charge, right? So, it has to maintain a register wherein it will specify what is the bank. Suppose I have a charge in SBI. What is the ID? Charge ID will be created. So that charge ID, I will have it. I will note it in the register. And what is the property I have given? Say if it is survey number 377 located at some particular state, that also I will make a note. What is the loan of the loan amount I have got? Say 5 crores. Then what are the SRN number? That also I will write it. Then that should be signed by the officer, or for each entry should have to be duly authenticated by the company secretary if there is one, or it will be signed by the official. Now there is a modification. So this is the original charge. So there is a modification. We used to write it as modification number 1. And we will say this 5 crores has been extended to say 7 crores. Then modification by way of, then the charge ID, whatever SRN number is there, that also we will do it, and there is a modification. So 5 crores has been increased to 7 crores. Then modification number 2, we will put the date. Date of creation. Say if it is created on 2020, 1/1/2020, I'm just giving you an example. Then modification could be on 1/1/2024. Then second modification could be on 22/2026. It could be anything. So modification to on which date it was modified. So which date it was filed with the ROC. Then they have satisfied, assume. Say after 3 years, then they will say satisfaction in full. So it will be for every detail, it should be signed by the person and it should be authenticated. So this we maintain it in the register of charge. So what are all the details? Now you can ask me. So one charge for SPI. Suppose the company has taken a loan from say UCO Bank. Then another charge. This is a separate charge. This is a separate charge. In UCO Bank itself, there could be a creation. There could be another charge created. Now I could have given property A. In another case, there could be another charge in UCO Bank by giving property B. So this charge is separate, this charge is separate. So which one you are making a modification? You have to make that entry correctly in that register. So what we used to do, we will keep the backup of the previous thing. So this is creation, this is modification 1, modification 2, modification 3. We write the entries in that respective page. Now it is, previously we used to maintain it in a book format. Now it is maintained on a digital format. In Excel sheet you can maintain it. So you have to make that entries correctly. So what was the modification done? In just a gist, you cannot write stories in that register. So just a gist of the important things that you should have to specify in that register of charges. So the registrar shall in respect of every company. Now he too maintains a thing. Register of charges to be kept by the registrar. Now what I am saying is the company is maintaining a register. The company is maintaining that register. The company also maintains a register of charges because it is creating the thing. The ROC will also maintain the register of charges in his department. So the respective ROC, suppose if it is ROC Punjab, he will be maintaining in his register. What is the register of charge? See, one doubt which students do is that you can give any property, but where the registered office is situated, only that registrar will be having your documents. So only there you have to register the charge. You might give any property located anywhere, whether in India or outside India, that you can give it. But you should have to register it with the registered office. Suppose your registered office is in Punjab, you have to register with the ROC Punjab. If your registered office is in Karnataka, then you have to register with the ROC Karnataka. So only he has the concept being, he only has the details of all your documents. Now, when it gets transferred, when you are shifting your registered office from Karnataka to Mumbai, then all the documents will get converted from Karnataka to Registrar of Mumbai. So that will be there. So the company also should have to maintain a register of charge that they will be maintaining. They will be maintaining the registers. Apart from this register of charges, they will be maintaining a statutory register, register of members, register of debenture holders, director shareholding, every register they will be maintaining. Apart from that, they will be having this register of charges also. The company will be maintaining the register of charges. Apart from that, the ROC also will be maintaining a register of charge. We will see by one of the provision. This is the concept. Now, register of charges to be kept by the registrar. Now, the registrar is maintaining what are all the details that he will write it in respect of every company. Company A, Company B, Company C, whatever company has been registered under his jurisdiction, in respect of every company, he shall keep a register containing the particulars of the charges registered under Chapter 6 of the Companies Act 2013. Now, that register will be maintained in the MCA portal, Ministry of Corporate Affairs portal. Once you get it, once you open, you click the name, automatically the charges will come. So it is transparent for any person to know what are all the charges that are live with the company. So that is deemed to be the register of charges maintained by the registrar. If you click mca.gov.in, then if you click the details, automatically the details will come. What are all the charges that are open? So that is the register of charges. And that is open to inspection. Suppose I want to inspect what are all the charges that are available for EPC company. I can do it. Any person can do an inspection in the portal. Need not be the bank. It can be a third party. Even you and I can make inspection and get the details. So it is transparent, but you have to pay fee for that inspection and you have to do that inspection. And now it is available online. Previously, we used to go to the ROC office and we used to take extracts from that. Now, after the introduction of MCA 21, you can get it online. You can also get the certified true copy from the registrar. You want to have a satisfaction of charges, that you want to have a certified true copy from the registrar on payment of fees, you will get the certified true copy from the ROC also. So this is with regards to register of charges maintained by the registrar. Now, the company should have to maintain. So how it is going to maintain that register? That we will see. Inspection of register, it is very less, 50 rupees or 100 rupees. Now, what is the amount? Very nominal amount only. You can get it. Yes, in this format, you can write it in the examination. See, your answer should convey all the points. You can write it in each point. See, I do it like this because each one conveys a point. Each bulletin conveys a point. So I have made it this way. So they should have to, the company should keep a register of charges in the form CHG7. So first point, every company, it is not one company. You should know how to write. Suppose write a note on register of charges is your question. So every company shall keep a register of charges. If you simply write a register, the answer is not complete. A register of charges in form CHG7 in which place? At the registered office of the company. So the third point is registered office. The second one speaks about form in the format. This is the format. Who should have to do it? How it should be maintained? Where it should be maintained? You get the answer for this, right? So for any answer, you should have to understand who's maintaining, how it is maintained, where it should be kept. You spend some time and then read it. Read it, you should have to slowly read it. You should have to write all the points. Then your point is complete. Then the register shall include means apart from other details, it should also contain the following details. All charges and floating charge. We learned there is a fixed charge, there is a floating charge, right? So floating charge on the working capital of the assets. It is floating, it is fluctuating in nature. So that is called as a floating charge. That you should have to write it.
Ma'am,
Okay.
could I take an example for the floating charge as I have a FD created in the bank of UCO, and from that we have bank given me as a OD faculty on that FD. So in the point of view bank, it's as a charge, right, ma'am? It's a type of as a charge which are created on the FD, right, ma'am?
Yes, yes.
Okay. So in that case, ma'am, then this charge nature is like a floating charge, ma'am.
It is a
means
floating charge only because it is on the current assets of the company. See, current assets of the company, if you take current assets, though this FD is if it is an investment purpose in FD, if it is a fixed nature on, it is an overdraft. If it is created on the current asset, say inventories, or if it is a debtors, then all these are on the current assets of the thing, then it is fluctuating in nature. So it is a floating charge. If it is of a fixed nature, then it is a fixed charge. Generally, we take it on immovable properties. That is a fixed charge. We take that as a fixed charge. Now it will fluctuate. No, if it is going to fluctuate, we take it as a floating charge only. Floating charge on the assets of the company. Right? And the banker it is depending on the banker, whether he can give a fixed loan on the fixed charge, or he can also issue a loan on the floating charge. For a business person, he may give you a floating charge also. So in that case, the person will repay immediately, or the overdraft limit may, or if it is a working capital loan, working capital will fluctuate. So in that case, it is a fluctuating charge only. It is not a fixed charge if it is on the floating assets. So whatever be the nature at the time, what is the nature of charge created, that you should have to write it in the register. Affecting any property or assets or any of its undertakings. Property, assets, or any of its undertakings, you have to indicate the particulars of that, on what is given as a security, that you should have to note. See, for removable property, we specify the survey number, or if it is a floating assets on created on all stock, debtors, assets, we just write it that way in the charge. And it should be kept at the registered office along with the register of charges. That instrument should also be kept. The instrument creating the charge should also be kept with the register of charges. So you should have to make the entries for that creation, modification, and satisfaction. As I told you, once it has been satisfied, you will write it as it has been satisfied in full. So there you should not do further entries there. So modification by mistake, we will not do it. So in that itself, we will mention that it has been satisfied in full. So creation, modification, satisfaction, everything will have to be written, and it should have to be authenticated. Authenticated means it should be signed. It should be authenticated by the director or the secretary or company or any person. Authenticated, it should be separately signed for each creation. So that is the proof that he has seen, he has verified. So it should be authenticated by the director or a company secretary or any person authorized. Right?
Ma'am,
Yeah, we need
in my given case, as an example of UCO Bank and me as a borrower and the charge creation, which are FD in nature, which are in nature of fluctuating, because I taken OD faculty from the bank. It is in nature change the rate and the fluctuate. Ma'am, in that case, we learned in earlier lectures, we learned about the crystallization method, means process of the charge. So in that case, in my case, can bank make a crystallization in case I default in the repayment within the prescribed limit issued by the bank?
Yes, crystallization of
So
charge
in
take
that case,
place.
we can make a crystallization portion. The nature of a fixed nature, no? Even I'm not repaid the loan and I'm default in the repayment of the loan. So bank can be crystallized. they have power to the crystallize by the charge, which taken by the bank from the me. So in such case, we can say ki it's a in fluctuating to the it's a floating charge to the fixed charge, right, ma'am? This we can say ki this type of characteristics are come to the floating charge.
No, in that case, when crystallization has taken place, fluctuating charge fluctuating charge or floating charge becomes the fixed charge. Then you cannot use the property. Once it has crystallized, once it has become a fixed charge, you cannot use the property. See, if it is a floating charge, you can use, the buyer will get it free of charge. You can use the property. You can use whatever in a fluctuating charge, that current assets could be used. You have given a stock as the security. So this stock could be sold. That is possible. But once it becomes crystallized, this floating charge becomes fixed. Then you cannot use the charge. You cannot use the property. So crystallization of charge takes place, fluctuating charge becomes a fixed charge, or the floating charge has become a fixed charge. You cannot make use of that property. You cannot use that property. Right? Yes, ma, I will give you a break. So shall we take a break and then we will continue? It is 7:42.
Realize for this property, no, for the
Pardon?
okay, shall sure.
Can you put it in a comment because your voice is breaking?
Okay, I'm proceed, ma'am.
Okay. So we will take a 10 minutes break and then we will meet. Right? So break for 10 minutes. Yes, these notes are available, ma. It will be shared. So, welcome back. Hope you all are back after the break. Shall we continue? Okay. So, the entries need to be authenticated by the thing. Now, you are asking me about the inspection of register of charges, right? So in the portal, a person should have to go and any third party can do an inspection. Any person can do an inspection. Need not be by any member or creditor or being by any other person. So any third person can also do the inspection. Generally, in the office, in the registered office of the company, also a person can go and do the inspection, or in the MCA portal, also it will be available. In that portal, you should have to pay the prescribed fees, and even in the portal, you have to do it. The articles will generally specify how much fees should have to be obtained for inspection. So based on their articles of association of the company, they will charge the fee for inspection. So when you go to the company and do the inspection, they will also have a register, or you can do the inspection in the ROC office also, or through online. Either way you can do it. So in both the cases, you should have to pay the prescribed fees. So this fees will be specified by the articles of association. For the company, when you are going to inspect, what amount it should have to charge, it will be mentioned in the articles. Whereas in ROC, it is a standard fee. Say previously it was 50 rupees. Now the current thing they would have increased. So on payment of the prescribed fee, you should have to do the inspection. You can get the extracts and you can take extracts of the register, and for your purpose, you can take it. And this register should have to be preserved permanently. And the instrument should be preserved for the 8 years from the date of satisfaction of the charge. Meaning that register should have to be permanent. It is a permanent register. It is a statutory register to be maintained by the company. So it should have to be preserved permanently. Whereas the instrument, you are giving a document. The instrument means the document with which you are creating a charge that should have to be preserved for 8 years from satisfaction. That is the concept. Now we'll take this MCQ. On receipt of, we will also solve that doubts after this MCQ is over. We will take that MCQ. I will take the 2 questions which was given by a student and your receiver. Those 2 things I will solve it. First, let me finish this MCQ. On receipt of intimation of satisfaction of charge, the registrar issues a notice to the holder calling a show cause notice within such time not exceeding a specified number of days as to why payment or satisfaction in full should not be regarded as intimated to the registrar. So what is the number of days? Show cause. Yes, many have done it correctly. It is 14 days. So 14 days notice will be given by the registrar to show cause why it should not be registered. So the banker is given 14 days time limit to raise the objection. That is the concept. So the answer is 14 days. Next MCQ. What is the prescribed form? This I gave you the other day. Anyway, for registering a charge created on debentures, it is CHG 9, right? CHG 9. For debentures, it is CHG 9. Only for charge, it is 4, CHG 4. Which of the following is not a consequence of non-registration of charge? Not a consequence. The other three are the consequences. This particular thing is not a consequence. So you get an answer for this. The other three are the consequences of registration, of non-registration of charge. But this is not correct. This is not a consequence. See, when there is a what are the consequences of non-registration of charge? The charge becomes void against the liquidator and other creditors. The charge holder loses priority over the other creditors. We saw as an example, it is there in your material. Vasudha Medicals or Medicos, and a big example is there that you should have to go through it. Then the charge holder is reduced to the level of an unsecured creditor. Does it mean that he need not repay the debt? No. See, once you have taken a charge, you have taken a loan, you have to repay the debt. The company is absolved of its liability to repay the debt. This is wrong. See, what are the consequences of non-registration of charge? It is void. If they ask you a descriptive question, how will you write the answer? Consequences of non-registration of charge. It is void against the liquidator or creditor. Then second one, loses priority. There is an example in the study material that you should have to go through it. We learnt it the other day. Then he is reduced to the level of an unsecured creditor. So this is right. This is a consequence. This is a consequence. This is a consequence. Whereas the company, the only security is lost. But he becomes an unsecured creditor. The company is liable to repay the debt. So, which is not a consequence of charge. You have to be thorough with the provisions. So, this will not come. So, the company is not absolved of its liability to repay the debt. C is the answer for this. Then, what happens when a floating charge is crystallized? The assets under the charge can be sold freely? No. Now you tell me the answer. Yes. So it cannot be used. The concept is in floating charge, you can use the asset. Once it becomes crystallized, you cannot use the asset. It cannot be sold freely. This is not possible. Then automatically released. Definitely not. It becomes a fixed charge. Can continue using the assets. No, this is also not correct. So the floating charge crystallization means it becomes a fixed charge. that it is crystallized. It becomes a charge and the borrower cannot use the assets. That is the main reason for this floating charge, crystallization of floating charge. Then, what is the extended period for a company to report satisfaction of charges to the registrar under section 82? Many are coming out with the correct answer. The answer is 300 days, right? When 30 days it has not registered, it has got an extension time up to 300 days for satisfaction of charge. It has got an extension of time. What is the penalty for a company that fails to comply with the provisions of Chapter 6 of the Companies Act? For the company, what is the many are coming out with the correct answer. 50,000 for the officer and for each officer in default, every officer in default. But whereas for the company, it is 5 lakhs, right? So B is your answer. 5 lakhs for the company and 50,000 for the officer in default. Now we will take one more, that fifth question. Under section 78, if the company fails to register the charge within the prescribed period, what is the next step for the charge holder? Company has failed. So the charge holder can yes, the charge holder can apply to the registrar for registration of charge. If the company has failed, the banker or the charge holder can register the charge. The answer is B. The apply to the registrar for registration of charge. That is possible. Now we will take the fifth FAQ. That was with respect to satisfaction of charge. Now, XYZ, a manufacturing company, has taken a loan from ABC Bank and registered a charge on its assets on January 1st, 2022. I think we did this question. No. One question we did not do. The additional charge, what additional fee it should have to do it? I think we did not do the sixth question. No, fifth question only. We will do this question. Fifth question. And registered a charge for the XYZ paid off the entire loan to ABC Bank on April 1st, 2024. According to Section 82 of the Companies Act, it was required to file an intimation with the Registrar of Companies regarding the satisfaction of the charge within 30 days from the date of the payment. However, due to an oversight, the company did not submit the intimation until July 15, 2024. To rectify this, the company decided to take advantage of the extended period of intimation provided under the proviso to Section 82, which allows for an extension of up to 300 days with the payment of additional fees. The additional fee for late intimation was 5,000 and the company's compliance officer needed to calculate the total fee to be paid for the delayed file. As per the given facts, examine by how many days XYZ Limited was late in submitting the intimation of satisfaction of charge. What additional fee should the company pay for this delay? Yes, many have come out with the answer. We will see. So what is the thing it created? Its creation was on the creation of the charge was on January 1st, 2022. The satisfaction of the charge was on April 1st, 2024. This was the date. So it should have filed on or before 30th April 2024, it should have filed. But the payment of additional fee. Now, how many days was the delay? May, June, July. May 31 days, June 30 days, July 15 days. So it is 76 days was the delay, and they have specified it as $5,000. I'm sorry, 5,000 rupees. So it is 76 days and 5,000 rupees is the delay. See, he has asked what was the, as per the given facts, examined by how many days it was delayed, was late. So the delay was 76 days. Option B, yes. Now, you were asking me two questions in that thing. I will be sharing that. See, this is a scenario. Mr. H acquired, one of the student has asked this. Is this question H acquired a property from PQR Limited which was mortgaged to ABC Bank. He settled the dues in full and the same was registered with the sub-registrar who noted that the mortgage has been settled. But neither the company nor ABC Bank filed the particulars of satisfaction of charge with the jurisdictional registrar of companies. Can H approach the registrar and seek any relief in this regard? So it should be registered under Section 77 of the Companies Act, but it is a public document. But if any person acquires a property in respect of which a charge is already created, it is no. I think this is a wrong thing. I will tell you just a minute. Okay, just a minute. So that question is that can approach the registrar and seek any relief. He can do it with the 300 days. Within that 300 days, you should have to do it. So this question, it is within 300 days, he should have to go to the registrar. Suppose that 300 days has also expired, then he can go to the central government and he should take the rectification of charge. That is the answer for this question. Now, you should also note what is the provision of section 80. Now, a person acquires while purchasing a property, he did not know that the charge was created on that thing. A person has asked the question. For him, the answer is this: a person has acquired a property or assets. The question is, a person has acquired a property and he was not aware of the fact that a charge has been created in that property. So what is the procedure? So for that, the answer is, it is there available in the model test paper. You can just go through it, but I will explain the doubt, what you should have to write. See, section 80 specifies that if any person acquires a property, assets or undertaking in respect of which a charge is already registered, it is deemed that he has complete knowledge of charge because it is a public document. See, it is treated as a public document, right? The concept is that it is treated as a public document. So it is available in the portal and he is aware of the charge because it is a public document. It is very well available in the portal. So he has complete knowledge. He is aware of the charge. So it is presumed that he has complete knowledge. Presumed that he has complete knowledge of the charge from the date of its registration. So any purchaser of that property should have to be very careful, ought to have been careful while purchasing that property. That is very, very important. Ought to have been careful while purchasing the property and should have verified beforehand whether the company had created a charge on that property or not. So there is a thing. So one of the student asked this question. So for that the answer is this. So the contention of PQR is correct. So the PQR Limited is saying that they are not responsible. Yes, the contention of the PQR, the company, is correct. The purchaser should be aware. So since it was registered in the portal, he should have adequate knowledge of that. That is the answer for this. Then you asked me about the receiver. I will share that. See, when will the receiver get appointed? See, when the intimation of that appointment of receiver, a student was asking. I will tell you. When the civil procedure code comes into the picture, the court has got power to appoint a receiver. Of course, the banker would have initiated or any third party would have initiated, but directly who has got the power to appoint a receiver? Only the court can appoint a receiver. So it can engage a person as a receiver to look after the property because the property could be in dispute because you are giving security as you are giving security as a property, or it could be on the basis of an emergency situation. It could be due to any reason. You can just go through it. It could be for any reason. The court appoints a receiver. If a person obtains an order for the appointment of a receiver, it has specified if any person obtains. When I say any person has got right to apply to the court, and because of that order. When I use the word order, that is again a costly word or a very important word. So to manage the property which is subject to the charge. Now I have given property A as security. Now a person has approached and the court has appointed a receiver. Or if any person appoints a receiver pursuant to the power contained in that instrument, then in either case, it should have to be intimated to the registrar. Is that clear? Now, who will appoint? Generally, the court only appoints the receiver. But in the second scenario, this is pertaining to the order. So definitely the court appoints. Here in the second case, if any person appoints pursuant to the power contained in any instrument. So if any person, here they have not used the word order. So whenever order comes, it is the court order. The court appoints a receiver or any person appoints a receiver, then it should have to be intimated to the ROC within 30 days. That you should have to get it. Yes, as per instrument. One is as per court, then other, the power should be entrusted in the instrument. Then he asked another question. That question also I will see. The question which was asked by Vijwal Arora is that I will share this also. I will copy paste that question. Wait. Okay. I will copy paste that question. This is one question. And the second question is, just a minute. So these are the two questions that has been asked that we will discuss it now.
Ma'am, we can't see your screen.
Now, are you able to see the screen? Now I'm sharing the screen, right?
We still can't see it.
Is it visible?
Now we can.
Okay. The Renuka Soaps and Detergents Limited realized on 2nd May 2024 that the particulars of charge created on 10th March 2024 in favor of Sankalp Commercial Bank Limited were not registered with the Registrar of Companies. What procedure should the company follow to get the charge registered? Would the procedure be different if the company realized its mistake of not registering the charge on 7th June 2024 instead of 2nd May 2024? Explain with reference to the relevant provisions of the Companies Act 2013. See, what is the rule? The general rule is that you have to create the charge. This is with regards to the creation of charge. So it should have to be created. When the charge is created, then within 30 days, you should have to creation of charge within 30 days. Right? If it is not registered within 30 days, then you have got further time limit of 30 days. Right? I will share the PowerPoint. for creation of charge. See here. You should have to register the charge within 30 days. Otherwise, you have to register it within the next 30 days. If it is not registered, then for the next 60 days, for a further period of 60 days with ad valorem fees. So 30 days here, let me write it. So 30 days, then next 30 days, this is with additional fee. Then for a further 60 days, then this is ad valorem fee, right? See, difference between ad valorem and additional fee is that additional fee you are paying a fixed fee. Ad valorem means on the value they will create a percentage on value. So that is ad valorem. Valorem means on the value you should have to do it. On the creation of charge, suppose the charge is 5 crores, your ad valorem fee will be different. If the charge is 50 crores or depending on the value, your fee will also get increased. So that is ad valorem fee. Additional fees means you are not bothered. It is the flat fee, or if it is whatever is the additional fee, depending on the delay, you will pay the fee. That is freezed. But here you don't know. So what was the question that was asked there? Just a minute. Now this is the okay. Now I will share the question. Now the question is, within 30 days, realized on 2nd May that it has created a charge on 10th March. So what was the delay? From 10th March, it should have filed. Creation was 10th March. So within 30 days. So it should have filed. But March gone, then March, then April. March 10th, if you calculate, it will come to 31 minus 9. That will be 22 days. 22 days, it should have filed on or before 8th April. 8th April, then 7th May. So on 2nd May, if it is there, it comes in the second slab. That is, it should have to pay. If it is realized on 2nd May, it will be it should have to pay additional fee. Right? Because what is the reason? It is within the next 30 days. Right? It is within the next 30 days, so it will pay only the additional fee. Now 60 days gone. So after, if it realizes on 7th June, then mistake of not registering, then it should have to pay. If it falls within the next 60 days, then it will pay ad valorem fee. That is the answer. Yes, the procedure would be different since it was realized its mistake of not registering. It should have registered within 30 days of 10th March. It has not registered. So March, April gone, May gone. Then June only. So it falls within the next further 60 days. So if it is on 7th June, it will fall within the next 60 days. So it should have to pay ad valorem fee for the delay. So that is your answer. So if it is on 2nd May, the company Renuka Soaps would have paid only additional fees. If it realizes on 7th June, it falls within the next slab rate, next 60 days. So it should have to pay ad valorem fee for the delay. You should have to explain it this way. Then next question, which was raised by the student, is that Mr. Antriksh purchased a commercial property in Delhi belonging to NRT Limited after entering into an agreement with the company. At the time of registration, Antriksh comes to know that the title deed of the company was not free, and the company expressed its inability to get the title deed transferred in Antriksh's name, contending that he ought to have the knowledge of the charge created on the property. Explain whether the contention of NRT is right or wrong. So this is where our section 80 comes into the picture. This question is also frequently repeated, right? This question, for this you should have to answer it this way. Section 80 clarifies that if a person acquires a property, assets, or undertaking in respect of which the charge is already registered, it would be deemed that he has complete knowledge of charge from the registration. So instead of Prakash, you can write it as Mr. Antriksh therefore ought to have been careful while purchasing the property and should have verified beforehand whether NRT Limited has already created a charge on the property or not. So in view of that, the contention of NRT Limited is correct. So this is the answer which you should have to give. Hope this clarifies your doubt. So for this, you should have to write the answer this way.
Excuse me, ma'am.
Yes.
I have one query, ma'am. Actually, when while dealing with the fixed assets, like fixed charge, like in case if a company fails to review the condition of the asset, due to some unavoidable circumstances, the asset got spoiled, and in that case, how will who will be reviewing other than company, and how will this work out in a practical real life?
See, when the asset is going to be wasted, the court will appoint. So that is one of the case where a receiver will be appointed. So that is one of the
Okay,
case
ma'am.
where a receiver will be appointed. So if you go through the thing where a receiver will be appointed, then one of the cases is that when the asset is going to lose its value, it is wasting, or the third party or a suit has been filed under the civil procedure code. It could be any reason. Because of that, the receiver was appointed. So it will be taken that way. So practically, suppose the asset is not in use. This is one angle wherein a receiver was appointed. This is one angle. Suppose the banker is not satisfied. What he will say, now the banker is, this is from the angle you can raise a thing and the court will appoint a receiver. Suppose the banker is not satisfied, he may ask for additional security. What he will do, he will release
Okay.
this asset and ask another asset, or he can keep the existing asset plus additional asset. So in both the cases, it amounts to modification of
Okay, ma'am.
charge because you are creating additional security. It is left to the bank. Suppose practically what
Okay, ma'am.
happens is that suppose I am giving property A. I have taken a loan in property A. Now there is a party to whom I want to sell. So I can request the banker to release property A, and I will ask the banker, instead I will give property B to you, adequate security. You please release property A. I will use this for selling it to another person. So in that case, your security gets changed. So it amounts to modification. So property B is your
Okay,
security,
ma'am.
change in the security, and property A will be released, and property B will be your security offered. Even that case is
Okay, ma'am.
also possible, but it depends on the bank. Some banks may accept, some banks may not accept, because there is a procedural thing. They have to note everything in the change. This details would have been recorded. So it is left to the banker. Or what he can do,
Okay,
if the property, your question is if property A is not proper, or some a decrease in value takes place. So in that case, the banker will ask for additional security. You may have to give property B also, practically. Because he will keep that. He will not do anything. With the existing security, he may ask the borrower to give a fresh security, additional security, because property A is useless, or it cannot be considered with its value. The value has reduced. It could be anything. So he may ask for additional security, in which case it amounts to modification of charge. Of course, the same
Oh,
concept.
it's a bank's responsibility to review the condition of asset, right, ma'am? Like in our
Yes,
case.
see, one thing practically you will say, see, I have borrowed. Will I say my asset is not sufficient? You take this property, borrower will never say. Who is the affected party? Who has given the loan? It is the bank who has given the loan, right? So bank will
Yeah, ma'am.
see to it whether it is adequately secured or not. So banker will only insist, no, this property is not sufficient. You give me additional property as security. So the banker will only ask. Why it will never be asked by the borrower? Why is he bothered? It is for him a headache, no? So he won't
Yes.
proceed with it. Banker accepts it. Yes, he's happy. Logically, you think. Are you getting it correct?
Yes, ma'am. Got it.
Okay.
Thank you.
So any other doubts?
Ma'am,
So
I
No,
hope
have
ma'am.
I have.
Everything is clear.
Pardon?
I have a doubt in MCQ 5 where we
Okay.
calculated the number of days of delay. There
Hmm.
will be not considered from the date of satisfaction. If we could just go to that.
I will go through that. Yes, I will do it once again. MCQ 5. Okay. Wait 1 minute. Okay.
For this,
See
will we
here.
not can take it from April 1st when we're
Okay.
calculating the delay?
See, the concept is that on April 1st, 2024, it has paid the entire loan, right? So loan was paid off on April 1st, 2024, the paid off the entire loan. It was
Okay.
required to file the intimation of satisfaction within 30 days of payment. So within 30 days on 1st April, so within 30 days means on or before 30th April, it should have intimated with the ROC. Now, it did not, due to an oversight, it did not submit the intimation till July 15th. Right? To rectify this, the company decided to take advantage of the extended period, which allows for an extension of up to 300 days. The additional fee was 5,000 rupees. And the company's compliance officer needed to calculate the total fee to be paid for the delayed filing. As per the given facts, examine by how many days XYZ was late. So was late, he is asking what is the number of days for delay. See, before 34, this is on time. The question is the delay. How many days delay? See, the question is you have got 300 days. Now, how many days was the delay in submitting the intimation of satisfaction? Now, April, in May, you have got 31 days. In June, 30 days. In July 15th only it realized. Until July 15th. So there was a delay of 76 days. Now the question was asked is how many days was late submitting the intimation. So the question is from 34, this is on time. From this day, what is the delay? So I took it as 76 days and 5,000 rupees.
Okay, ma'am.
Is this clear?
Yes, ma'am. And if we had to calculate from 1st of April, then what would have been the question?
They would have asked from the date of satisfaction. In how many days the company was, the question would have been, what was the number of days delay from the date of satisfaction? If the question was framed that way, then you should have to take it as 76. You will include that 30 days also.
Okay, ma'am. Understood. Thank
So
you.
then it will be that many number of days. Right?
Yes, ma'am.
Okay. So hope I have covered the entire questions and your doubts. Yes. So a quick, yes, thank you. So we will be, yes. Yes, what is your note? So hope it is clear. Registration of charges is clear. Yes. Thank you, everyone. And I enjoyed the session. We will be having, we will be meeting in the next class with management and administration. So go through the topics and we will have a good session. Yes, thank you all. Yes, have a good day. Thank you.